I just walked out of a subcommittee hearing with Oversight and Government Reform with IRS and Treasury and individuals from states looking at the interpretation that the IRS and Treasury has for a section of Obamacare. It's highly technical, but incredibly important to us. The way Obamacare was written, and when it was written in the Senate and sent over to the House, there's a section of it that defines out the role of the state exchanges, and it mandates that subsidies that come to states only come through those state exchanges. It's very clear in the law. It's in Section 1311 of that law. Well, the problem is 34 states chose not to do a state exchange. They have a federal exchange. And so because of that, no subsidies should go there, and also no penalties should actually go there. Well, the IRS and the Treasury has now interpreted that as no, it was assumed it would be all state, even though the law doesn't say that. Well, that's a problem. The IRS and Treasury can't come back and just say, well, we'll just assume the law should have said this and change the law on the fly. You have to go by the statute. Now states are saying, including my own state of Oklahoma, are saying people in my state will be affected by this law because we're a federal exchange state, but we're getting all the penalties as if we weren't. We've got to fix that. That's a major problem.
Well, the state's going to be affected, in Oklahoma particularly, because Oklahoma made a decision not to adopt an exchange, and as a result, the employer mandate penalty could not be assessed in Oklahoma. The IRS has taken that decision away through rulemaking from May of last year. Our lawsuit is about doing something about that, to prevent the IRS from enforcing it in that fashion. I mean, the most important component from an Attorney General's perspective, from a state perspective, is that the state has made decisions not to expand Medicaid. The state of Oklahoma has made a decision not to expand Medicaid and not to adopt a state health care exchange. We are in the process of giving life and meaning to that, to make sure that the courts recognize that and prevent the IRS from taking those decisions away. And so if we are successful in our litigation, then the IRS will not be able to assess the employer mandate penalty in Oklahoma. And that will be a good thing for our state because it upholds rule of law.
This is the first hearing that's ever been held on this topic. This has also started its way through the court system as well, and will be a defining moment again in the court system. Can the IRS, can the Treasury Department come back and rewrite a section of the law and just change it and include another $600 billion plus in spending based on their interpretation of the law, or do they have to actually go by the statute?
But I think the committee process brings awareness. On the panel today, we had 4 individuals from different perspectives. One who believes that the law should be interpreted differently than what Oklahoma believes, academicians, law school professors, and that dialogue is very important for the members of the committee, to be able to hear from folks that are affected, that are in the process of implementing the law, and giving, again, meaning to what Congress has passed. So this process brings awareness, it educates, it informs, and it also, I think, brings accountability. Accountability is a very important component as it relates to this law, because the IRS, in my estimation, is acting inconsistent with the statute, and accountability needs to be a focal point.